Case Closed with Kish.
Good evening, everyone. Welcome to the third episode of Mitch the Tax Man business show. Thank you all for joining us this evening. Just gonna move it that way. Delighted to be joined by a special guest this week, Martin Levison. Thanks for joining us.
Pleasure.
We've had some amazing feedback from our last show. And just another congratulations to Jonathan Lee, who won the prize for giving us the best question from the last show. And Jonathan will be joining myself and Kishan at the Yacht Club. And this show we have another prize, which Martin will explain shortly, for the best question asked to myself or Martin. So make sure that you're joining in, you're sending us your questions, and we'll answer them. So, Martin, thanks for joining us. Martin is the Director of Guardian Inheritance, and just coming back to the feedback was get maybe a bit more grey hair on the show, but I went one better. I got no hair. Martin's Director of Guardian Inheritance. So, Martin, you were in Japan last week.
I was in Japan last week. Got caught up in the earthquake. Very exciting.
Okay, and you survived it?
Well, just about, yeah. I think it was a cue to get me out of the country. Woke up at about 9:30 their time because I had an early flight the following morning. Thought someone had jumped onto my bed. Sadly, not the case. But the room was rocking and rolling, and just like Elvis, but without the melody. Very exciting. Okay,
great experience. So I'm going to go straight into it. So you retired when you were 37. Amazing achievement. So what brought you back into work?
My wife did, actually. She gave birth to our third child. And when my wife told me that she was pregnant with our third child, it came as a pleasant surprise. I'm going to say pleasant surprise because I don't know if my wife will watch this, so I can't say shock. Our little one wasn't planned, but blessing nonetheless. A blessing nonetheless.
Okay, so you qualified as an accountant, you built up your practice and you sold it when you were 37. Do you see any changes? I know you're not in accountancy, but from back then, which was...
Not before 1990, qualified in 76.
Okay, so 1976, so for those of us who weren't around in 1976, so you're going to get a bit of an insight of what life was like. Do you see any major changes in the profession from then to now?
Well, I do. When I started in accountancy, we were not allowed, there were no such thing as handheld calculators. We had two adding machines in the office and we weren't allowed to use them. We had to add up. It was pounds, shillings and pence in those days, long before your time. We had to add up using our brains. Amazing. I found the brain. And that was interesting. Then we got computerised in the office, in my office, but we still had to know which side of the cash book checks received went on. There was a debit and there was a credit. Nowadays, I don't think any of the newly qualified accountants know what a debit is or a credit is. They know what a payments routine is or a banking's routine and which buttons to press on the computer. God bless them.
Okay, so let's just have a look who's joining us. We have 7 viewers at the moment, so let us know you're here. Leave your comments below, and let's just go on to a prize. We're going to give away a prize to the best question. So Martin's kindly sorted out the prize for today. So Martin, do you just want to explain to everyone what the prize is?
I'm going to be sending a copy of a book by Michael Gerber called The E-Myth Revisited, which is one of the very best business books you will ever read. It's a funny old thing though about having as it were, a self-help book or a business book. It's not good enough just having the book. It's not good enough just having the book and reading the book. You've got to have the book, you've got to read the book, and you've got to apply what you learn in the book.
Okay.
Miss any one of those three, you might as well miss them all.
Okay.
But it will be in the post to the person that submits the best question.
That's it. So guys, an amazing prize there. Words of wisdom, get your books, get your questions in. So let's come up to today. You are the Director of Guardian Inheritance. Do you just want to explain to everyone what Guardian Inheritance does?
Yeah. We started off, I got involved in the business 9 years ago next month, and it was a will writing company. Today, however, we're a little different. We're a legal firm, if you like. We're not a firm of solicitors, but we're a legal firm. Although our core business is legacy planning, which is a fancy name for estate planning, we also do things like matrimonial or conveyancing. We do a lot of trust work. We do accident and injury, prenups, shareholders agreements, all that, and a load more stuff. And we do it through our own legal department, and also we work very closely with barristers' chambers, who do a lot of our trust work for us.
Okay, fantastic. So we'll just talk about a couple of the services there. The first one, as you said, the will writing. So I know there's a stat. I can't remember exactly what it was actually. Say hi to Kim Fox.
Hi, Kim Fox.
Who is that from? So there's a stat. What is it? Something like 80%. Is it 80% of people in the UK do not have a will?
Well, the fact of the matter is that wills cannot be found for about 70% of the people who die in this country.
Right.
So does that mean that 70% of the people in this country don't write wills? Probably not. It's a mix between writing a will and putting it somewhere so safe that nobody ever finds it again, ever, and not writing a will at all.
Mm.
One way or the other, wills cannot be found for about 70%, over 2/3 of the people who die in this country today. And that, particularly if you have children, is an absolute sin.
Okay, so let's just come on to the main reasons why people should write a will.
Do you know, there's a lot to be said about writing a will, but in point of fact, if you don't have a will, don't worry, because the government has got one for you. But your assets won't go where you want them to go necessarily, or in the shares that you want them to go in. So if you've worked all of your life, you know, we drag our bones around this planet for 70 years and 10, and when we die, if we're worth £5.26 or 57 million, in my view, and it doesn't make it right, it just makes it my view, it's only fair that your £5.56 or your 57 million go where you want them to go. Mm. The only way that's going to happen with absolute certainty is if you have a properly drafted will that passes probate.
Mm. And you touched upon before the importance of people with children having a will. So just explain as to why that's important for parents.
If you have no assets whatsoever, none at all, you live in a rented accommodation, you live in hand to mouth, week to week, the money runs out before the month runs out, but you have young children under the age of 18 or with special needs, there is only one place that you can instruct, where you can appoint guardians. And the guardians are the people who will look after your young children should you and your partner die before the children reach 18. Not surprisingly then, that one place is in a will. It doesn't matter whether you've got them as godparents, it doesn't matter whether you write a long letter naming the people you want to look after your children and sign it, it won't work. A will is the only place where you can nominate the people who will look after your children should you die before they reach 18.
Yeah.
If you are a parent with children under the age of 18 and you haven't written a will to appoint guardians, I have it on good authority that you will burn in the fires of hell for all eternity.
Okay, yeah, you've heard it here, maybe not first. So say hi to Cody Hayes. Who's messaging this? who have we got on? Let's see who we've got on. Guys, give us a wave. What are those comments there? Can you see?
No, you get to my age, I can't even see.
Oh, you can't see. We got Sophie. Who else we got on? Adam. Adam Morris. How you doing?
Adam Morris.
Thanks for joining us, guys. Get your questions in. We're talking wills. We're talking tax. We're talking business. Ask Martin. He's here for the next half an hour. Get your questions in, and you win the great book. What's it called? The E-Myth?
E-Myth Revisited.
E-Myth Revisited.
It's the very, very best business book you will ever have.
Yeah, we're talking wills at the moment, and the importance of parents to appoint guardians in their wills. And I know there's going to be a lot of parents watching this tonight, so let's make sure we get the wills done. And you also touched upon why it's important to keep the will safe.
Absolutely.
So a lot of people might have done their own will or just put it in under their pillow, or I don't know. So just explain if a will gets invalidated or ripped or that will.
If the will is, the fact of the matter is that a lot of people will attach notes or something to the will. For example, John, will you look after my cat? Or whatever it happens to be. I want my kettle to go to my brother-in-law, or some nonsense. If you attach anything to the will, even if it's only by paperclip, you run the risk of invalidating the will.
Yeah.
Because when the will goes to probate, they'll see marks on there, paperclip marks or staple marks or a pin mark, and they'll think something's been removed. Something like a codicil. And they won't know how many codicils there were to start with or how many have been removed. So the will is invalid. The problem with keeping the will at home is that the likelihood is sometime or another you're going to attach something to it, or it's going to get damaged. You might have a leak in the roof, or a pipe that bursts that damages it. Ink might smudge on the signature somewhere. The grandchildren might draw all over it. Nobody's there to check that it's signed and witnessed and dated correctly. The dog might chew on it. All of those things are likely to invalidate the will at probate. And the big deal about having a will invalidated at probate is it's too late, because you can't come back and write another one. So having the will stored properly, if it's stored with us, the first thing we do is check that it's signed and witnessed correctly. And if it's not, then we'll do another one and send it back and tell you where you went wrong. Yeah.
So that's great. We're up to 10 viewers, and Guardian have their own storage facility, and it's a bit of peace of mind when you die, you contact the beneficiaries. And
well, we do more. We do better than that. Once we've got the will and we've checked that it's okay, we let the client know that we've received the will. Obviously, we place it in the storage. It's our own purpose-built vault. But we also write to the executors. We let them know they've been appointed executors. We tell them what their responsibilities and duties are. We let them know that we have the original wills, and we tell the executors how they can release those wills when they need to.
Yeah.
Obviously, what we don't do is tell the executors what the will contains, what the value of the estate is, or how it's going to be distributed. Because if we did that, we could find the client's brake cables cut the following morning.
Yeah.
So that way, at least when somebody dies, the executors know who they have to contact, and as long as those executors are in mainland Britain, we'll deliver that will to the executor by hand. Right. So there's no question of it getting lost in the post. Somebody better looking with more hair.
Okay.
But it's also important. It's important to note that before we release the will, the executor has got to provide us with a proof of identity to show that they are the executor, and a death certificate, or they're not going to get the will.
Okay, that's a great service there. We have lots of questions. We've got a few comments. I can't see them, but I've got a little microphone in my ear. So we've got Jazz. Jazz, do you know someone called Jazz?
I know someone called Jazz.
Okay, hi Jazz. Thanks for joining in. What am I looking at? I don't know. It's not up. It's not up. I can come closer. Richard J. Okay, can you not? You can read them out if you want. You can read them out.
Okay, I'll read it out.
Questions.
Okay, Richard J. You say, on your validation point, read will. Why don't they add page numbers, i.e., page 1 of 2?
Doesn't stop codicils.
Is that a question for me or Martin?
I think that's probably for Martin.
Doesn't stop codicils. The pages are numbered, and it will say 1 of 4 or 1 of 5 and 2 of 4 or 2 of 5, but it doesn't stop codicils being added afterwards.
Just for people who don't know, what is a codicil?
Codicil is a separate legal document that should be read in conjunction with the will. It needs to be kept with the will, but not attached to the will, for the reason I mentioned earlier on.
Okay.
So some people have one codicil. They may want to change an executor, or change a legacy, or change a guardian, but the rest of the will may stand exactly as they want it. Trouble is, we don't know how many codicils somebody wants, and the number of codicils is infinite.
Yeah, great question, Richard. Thank you for that.
Good job.
Next one's from Kalpesh Patel.
Kalpesh, good to see you. Thanks for joining in.
Okay.
I'm a big fan of Mitch the Tax Man.
So the question is, how often do you need to get your will reviewed?
Great question.
We recommend you review your will every 4 or 5 years. Now, that doesn't mean that you have to change the will. It just means you have to look at it and see if it's okay. And if your wishes and circumstances are still the same, put the will away for another 12 months, have another look then. If they change at that stage, update the will and put that away for 4 or 5 years. Unless... Sorry to interrupt your interruption.
Yeah,
unless you've had children in the interim, or you've got separated, or you've got divorced, or you've got married. If you get married and you've had a will already, the will, your existing will is invalid unless that will was written in contemplation of marriage.
Yeah.
So unless there's a major life-changing event like having children, separation or divorce, or marriage, as a standard procedure, we recommend every 4 or 5 years review your will.
Okay.
Nice question.
Yeah, great question. Thanks.
Another question there from Sophie. First of all, your kids are asleep.
Okay, great news. It must be me. They never sleep when I come home. But yeah.
Okay,
good.
the question is, what happens to your kids if you don't have a will? That's from Sophie.
Okay.
Well, they live with you.
My kids or anyone's kids?
Is that for me, I wonder?
Well, I have a will, so we can just check the will.
If you have a will, if you have children and you don't have a will, the children live with you. You mean what happens if you die and you don't have a will? Social services. Thank you, Sophie. I know where you live. Social services are likely to get involved, which means the kids could end up in care for a while, whilst the mother's family wrestles with the father's family in front of a family court judge to see who takes custody of the children. I don't know which judge that will be. I don't know how long that will take. And would the judge make the right decision? Well, the answer is they'll make the right decision based on the information they're provided with. Will it be the same decision the parents would have made? We have no idea.
Yeah.
But why would anyone take a risk?
Chance, yeah. No need to take a chance. Guys, we're talking about the importance of writing a will. Some brilliant questions there on wills and will writing. Keep the questions coming in. We're up to about 200 viewers, so that's amazing. Thanks for the support. Adam's got a cough, so send your cough medicine infusion. We're going to move on from wills. But some great advice there from Martin. And we're going to talk a bit of tax. Why not? So, inheritance tax. You do a lot of trust work. Are trusts a good vehicle to mitigate inheritance tax?
If the client has assets which are structured in the right way, they're a fantastic vehicle, absolutely fantastic vehicle. The answer is you place an asset into trust, you live 7 years. It's like giving an asset away, but you're actually giving it away to future beneficiaries of your choosing. It also has the benefit of making sure that the people that you choose to benefit, typically the children, will benefit in due course, and that it guarantees a bloodline inheritance. So ex-daughters-in-law or ex-sons-in-law somewhere down life's road won't get their hands on the stuff because it's in trust.
Yeah.
Whereas if the children were to inherit directly when the parents die, and in divorce or whatever it is, their ex-spouses will enjoy the benefits of your labours.
Yeah, yeah. We're talking inheritance tax. One of the worst taxes, in my views, that you know you can pay, but there's ways, if you do the right planning, that you can obviously reduce that, and it's coming out of your inheritance for your loved ones. So make sure you're doing your inheritance tax planning. We're doing a lot of work on property at the moment, property tax planning. I mean, what's your opinion on how the government have just attacked landlords over the past, in the last budget and now?
Well, I'm not overly impressed, to be honest. I'm not overly impressed. I don't find it a sin to want to invest in property. I don't find it a sin to want to increase your net worth. I don't. I mean, that's what we do naturally as human beings, by and large, if we're able to. And if we are able to, why shouldn't we do it to the maximum of our ability without having someone slide up behind us and dip their hands into our wallets and take money out? We have to pay tax. Of course we have to pay tax. But it should be a reasonable amount. And in my view, without getting too political, the government is now coming up with new ways of taking money out of our pockets.
Okay, so let's try and help everyone without getting into two bits of specific planning. The use of a trust and putting property within a trust. Talk to me a bit about the mechanics of that.
You know what? It's not as tough. It's not as difficult as it seems. It's a matter of signing 17 pages of trust documentation, where we say sign. What would happen what would happen then is that the trust is transferred, as it were, into the property is transferred into the trust name. If there's no mortgage on it, land registry is notified. We prepare all the paperwork. Land registry paperwork's done, and then all of a sudden the property is owned by a trust. The people who control the assets in the trust and any income that's derived from those assets will be trustees that you nominate. So it's all in the family, as it were. It's not a case of us trying trying to get ourselves into a trusteeship where we can earn a regular income.
Yeah.
This is people that you know and you should know and trust, and you appoint them as trustees. The beneficiaries typically would be the children. Income, if you've got a rental if you've got an investment property, it goes into trust. The rental income would go into that trust. The mortgage, if there is one, will be paid from that rental income. Any running expenses will be paid from that rental income. Any profits on that rental income will have to be taxed in the usual way, but they would if you receive them personally anyway. Any capital gains tax on the transfer of the property into trust will be held over if your accountant fulfills the right forms, makes the right applications.
Okay, held over meaning
that the capital gains tax won't be paid until the property is ultimately sold.
Yeah.
And the children can benefit from that. So you could the fees, for example, the profit rental income after expenses can be used to fund school fees or university fees or a wedding or a bar mitzvah or a deposit on a house for the children at some time down life's road.
Yeah.
Fantastic vehicle.
Yeah, so we're talking about the use of trusts and putting property into a trust. We're talking tax and inheritance tax. Keep your questions in. We have an amazing prize which Martin's kindly ordered, which is a book. Which book's it?
The E-Myth Revisited by Michael Gerber. Worth reading. If Michael, and he comes over from time to time to talk in the UK, worth going up there to have a listen.
Yeah, the book, it won't look something like this, or this. But for the best question asked, Martin is going to hand deliver the book. Yeah, was that right? Is that what you said?
By post. I'm going to hand deliver it by post. You have my word on that.
Yeah, we're nearly on 20 viewers, guys. Get your questions in. We're talking tax, we're talking wills, we're talking trusts, we're talking business, networking. We're going to come on to...
We've got another question here.
Oh, and Adam's back.
I'm back from my coughing fit. Kishan. Hi, Kishan.
Kishan, how you doing? You made it.
Okay, so Kishan's question is, how can trusts protect my assets and properties if I were to get a gold digger and be divorced?
Well, that's a good question now. It depends...
Well, you're not going to get a gold digger.
But you might get divorced.
But yeah.
Well, first, Kishan, you've got to get married, as I understand it. It may or may not protect those assets, Kishan. If the assets initially were owned jointly with your yet-to-appear wife, if the assets are owned jointly with your wife, and you and the wife put the asset into trust, it depends on the type of trust. If it's a pilot trust to save inheritance tax, so you can't do it with your main residence, then you have to lose all control of that asset and any revenue it generates. The beneficiaries will be the ultimate beneficiaries. That way, if you get divorced, neither you nor your wife will enjoy the benefits of that trust. If it's a type of trust where you might put the matrimonial home in to give you all sorts of other protections, and if it's owned jointly by you and your wife to start with, then you and your wife will remain trustees, and she has the same rights that you do. If the property is owned by you, and then you get married, but you still own the property, and you put that property into trust, then you divorce, then you've protected that property from any divorce settlement that may arise in the future. So the answer is own the property in your own name, and then transfer it into trust. We've got to be careful about the values that go into trust for tax purposes, but we'll worry about that in due course. Yeah. First find a wife and then do the transfer.
Yeah, and if you need any help finding a wife,
don't look at me.
We've got another question here from Anura.
Hi Anura, thanks for joining in.
The question is, I deal with clients with assets overseas. Are you able to help clients in this position?
We have to refer them. We have contact, depends where overseas, Anura, but we've got contacts with legal people in various countries, and then the answer to that is a definite maybe.
And obviously from the tax side, anything tax, you can obviously refer into Fusion Consulting, and we can deal with the tax side, international tax, and the UK side of things. But thanks for the questions, keep it coming. We're up to 19 viewers, guys. Give us a wave, let us know you're here, get involved. We don't bite. We're talking tax, inheritance tax, wills, trust, probates, business, networking, whatever you like. My beard's had a trim. No one's mentioned that since last time. How smart this is. talking trusts, trusts can save probate fees. Now, yeah?
Oh, yeah.
So probate fees, it's been in the news recently. I know there's been increase in probate fees. You just want to touch upon that?
Yeah, it's a discussion paper at the moment, but presently, another way that we have to pay the government some money, when we die, if we've got assets over a certain amount, we've got to apply for probate. Currently, regardless of the size of your estate, £215 application fee, done and dusted. If the government have their wicked way with us, that could go up to a £20,000 application fee for estates of £2 million and over. That's a lot of money.
Yeah.
That's a phenomenal amount of money. If you place any assets in trust, including a matrimonial home in certain types of trust, that falls outside your estate for probate purposes, as long as there's no mortgage on it. If you've got a mortgage, we can still transfer the equity in that property into trust with a deed of equitable assignment, but it's only fully outside your estate for probate purposes once the mortgage is settled and the land registry documents are lodged. So if somebody got a house paid off, no more mortgage paid off for the house they've owned for however long they've owned it, they live in it, they transfer that into a particular type of trust. Our name for it is a legacy trust. Doesn't matter what it's called. You still live in it. There's no inheritance tax saving, but it falls outside of your estate for probate purposes. It also offers a phenomenal number of protections for yourselves whilst you're living and for your beneficiaries long after you die.
Yeah.
But if the discussion document goes through, you could save thousands of pounds in application fees alone by having a legacy trust in place.
Yeah, so much to think about, so many costs and to be saved, so make sure you're getting the appropriate advice. Speak to Martin, Guardian Inheritance, www.guardianinheritance.com, check out his website. So let's just talk a bit about, let's move on from the wills, trust and probate and just generally talk about owning a business. What's the toughest thing, in your opinion, about owning your own business?
Not getting involved. The toughest thing, from my view, is not getting involved, not micromanaging. The thing that should be done, the trouble with small businesses, and every business when it starts is small, every business when it starts is small, is that the people who start the business feel that no one can do it better than they can. They do it better than anybody else. Read Michael Gerber's book. He should pay me for this. The fact of the matter is that's not true. Mitch, I love you. You're the best tax man I know. But you're probably not the best tax man in the world.
No.
Maybe tomorrow you will be, but then the day after not so. Maybe Wednesday next week you will be again, but on Tuesday of the week after you won't be. So you're not the best. I'm not the best. None of us is the best. And there's so much stuff that we don't know about business. And we're frightened to find somebody that knows what we don't know, get them with us and pay them what they're worth, not what we can get away with. And if those people who are starting their businesses afresh, or they're fairly new now, if they've got that glass ceiling above them of believing that they can do it better than anybody else, do yourselves a favour. Go to bed and wake up tomorrow and realise that's not true. Get people with you who are better than you are.
Yeah. Great advice. Guys, we're now moving on to business. Martin's owned a few successful businesses and currently the owner of Guardian Inheritance. So we're talking business. Any business advice or tips, questions, whatever you want to say to myself or Martin, get them in. We've had 3 or 4 great questions. The winner is going to win a book. What's it called?
It's called The E-Myth Revisited, and it's by Michael Gerber. I'm going to write to Michael, I'm going to contact him on an email, and I'm going to ask him to send me some royalties. This is ridiculous.
Yeah. Okay, so LPAs. What's an LPA?
Well, I wish I knew. An LPA, the thing about wills is that they only come into effect when you die. Until then, the will is a useless collection of paperwork. It does absolutely nothing. It carries no weight. It will only come into effect, and when it comes into effect, on the very moment you die, it will be the most important document you've ever owned. The problem is that things can go wrong before you die. More and more of us are living longer and longer. You can tell, just look at me.
Yeah.
And as a result of that, statistically, there is a far greater chance that at one time or another, we are going to suffer some form of dementia. whether that's as a result of an accident or an illness, or whether that's as a result of a stroke or a pulmonary problem, or whether that's as a result of wear and tear or common or garden Alzheimer's. And if you lose capacity, then you lose control of your finances, because as soon as social services become aware of that, and the doctor will be aware of it, and he'll notify social services, and social services must notify, they've got a duty of care to notify the Court of Protection. And the Court of Protection will freeze all of the assets of the vulnerable person, including bank accounts. And here's the kicker, including joint bank accounts. So if you've got a joint bank account with your spouse or your partner, or your brother or your sister or your children, and you lose capacity, even the joint bank account is frozen. They cannot touch it. There was a statement from the British Banking Association recently that said, if you are a joint account holder with someone who loses capacity, you no longer have access to the funds in that account unless you have an enduring power of attorney in place, and they went out of fashion September 07. Or you have a lasting power of attorney in place, they came in on the 1st of October 07, or you've got an order from the Court of Protection. The next thing the court will do is appoint a court-appointed deputy who's likely to be a local solicitor. And that local solicitor will take control of all of the assets of the vulnerable person, including the joint bank accounts and any other bank accounts. And he'll pay all the bills out of them. And he'll make sure all the standing orders and direct debits are sorted, and all the dividends and interest and pensions are being received. And he'll make a charge for it. And in London, that could be £400 or £500 an hour. Every hour that he spends on your stuff, every month, every single month. And for doing stuff that your spouse should be doing for free. And the only way you can wrestle control back from him is for someone to make a claim to the Court of Protection for a deputyship order. And that's going to cost over £2,000, which must be paid by the applicant. And in 8 out of 10 cases, applications made by lay people fail, and there's no refund of that money. So, draft lasting powers of attorney, whilst you still have capacity, boys and girls, serious stuff. Draft lasting powers of attorney. For a few hundred quid and no ongoing fees, that's all sorted. Otherwise, it could be £500 an hour every month from a local solicitor acting as your court-appointed deputy. And there's no escape. There is no escape.
Yeah, it's very sad and serious stuff, but LPA is really important. Again, there's lots of information on Martin's website with the different LPAs on finance and health, so check that out. Right, let's try and get people upbeat a bit more after the whole LPA. So
you're all going to die.
Yeah. You're all going to die, yeah. Let's go back to business owners. So where we were going with that is that you were saying not to micromanage and the importance of getting the right people in who are better than you.
Absolutely.
So what do you look for in an employee? All right,
it's real simple. I no longer do any of the interviewing in Guardian because I'm not clever enough. But the people who do the interviewing in Guardian, I've asked them to look for one thing only. Say, I'm not interested in what school the applicant went to. I don't mind what GCSEs or O-levels or A-levels they've got. I don't mind what college of further education or university of higher education they went to, and what degrees or whatever they've got. I don't care what their past work history is. What I look for, and what I ask the panels that do our interviewing for us, I ask them to look for the right attitude. I look for people with the right attitude. This is an attitude that says, don't tell me it can't be done, tell me how we can do it.
Yeah.
That's the attitude I'm looking for. I'd rather work with someone that's got 50% ability and 100% attitude, rather than 100% ability and 50% attitude, because I can't improve their attitude, but I can improve their ability. Yeah. So that in a nutshell, we look for people with the right attitude. We don't always find them, because that's human nature. They'll tell us what they think we want to hear. So that's why I don't do the interviewing, because I'm an easy mark. But we look for people with attitude. I would strongly advise anybody who needs to take on staff to find people with the right attitude. Don't tell me we can't do it, show me how we can.
Yeah, great advice. Great advice there, guys. Get your questions in. It's good to see some more people joining us. We've got any questions coming in? No questions at the moment. Guys, questions to myself and Martin. We're talking tax, business, inheritance tax. We're going to move on to networking now. So Martin, you are the owner or co-owner of a franchise, the largest networking organisation in the world, the franchise in Japan. So it's fair to say, or one would assume, you know a bit about networking. Well, you certainly had a bit of experience in networking.
I know a little bit about networking.
And that's how we first met in networking.
Absolutely.
So we've got over 25 viewers. Good to see everyone. We're talking networking. What do you think are the key things that are important for someone or a business owner? Do you think it's important to go face-to-face networking to generate sales for a business?
I think you can do a lot worse than go face-to-face. People buy people, Mitch. They buy people. I wouldn't buy a newspaper from somebody I didn't like. I'd walk down the road and buy it from the shop across the street or wherever it happens to be. It's important that that you deal with people you know you can get on with. There's a book called Good to Great, which is...
That's not the prize.
That's not the prize.
That's not the prize.
So we've got another question from Richard J.
Oh, Richard J.
Who's very active today.
He wants a book.
He does want a book, doesn't he?
Yeah.
He says, lots of banks offer free will writing services if you pay for packaged accounts. What's the benefit of using someone like you, Martin, as opposed to the banks?
Richard, you don't know any bank managers who are as good looking as I am. Unless you can see. The fact of the matter is that a lot of the banks that offer free wills will also endeavour to appoint themselves as joint executors. They are a business after all, and you can't blame them for trying to appoint themselves as joint executors, because when you die, and sure enough you will, they will start the probate process. And a couple of articles in the press a few years ago, 3 or 4 years ago, one in the Guardian, one in the Times, did a survey on probate fees and the comparison between what banks would charge compared to what solicitors would charge. They found that banks were charging between 4 and 8% on average of the value of the estate to put an estate through probate. That's a lot of money, Richard, a phenomenal amount of money. So it's no wonder they offer free wills. But in addition to that, you won't get the advice that you get from us about who to appoint as executors and what the executors' duties are. You have to attend their premises, whereas we'll come round to you any time between 10 a.m. and 8 p.m. Monday to Friday and 10 to 4 Saturday and Sunday. All you've got to do is make it as far as the front door and put the kettle on. Also, we'll advise you on guardians and their responsibilities if you have children under 18 and it's appropriate. We'll advise you on your inheritance tax position briefly. You don't get in-depth advice, but you get a broad outline. We'll advise you on how you can reduce probate costs. We'll advise you on how you may be able to reduce inheritance tax. We'll advise you on the importance of storing your will. Anything else? Are you still with us?
No,
he's he does make a very good cup of tea, actually.
Yeah, it's important, so that's fine. Richard, thanks for the question. We're just talking networking because Martin is the co-owner of a franchise in Japan of the world's largest networking organisation. So we're talking networking, right?
The importance of getting face to face.
The importance of face to face, yeah.
Invaluable. In my view, it's important that people get to see you.
Yeah.
And whether you don't like it or not, smile. Because when they see you, if you're smiling, I mean, not all the time, it mustn't be like rigor mortis, but you've got to be approachable. People need to approach you.
Yeah.
You've got to. It's a relationship business. You've got to build relationships with people.
Yeah.
You can do it on LinkedIn and other networks are available. What I've found, let me tell you this, I've found on LinkedIn, I'll connect with somebody, and before I know where I am, they've made contact with me trying to sell me their services or their product. I mean, that's definitely not the way to do it. And when you're networking face to face, the first thing you don't do is, after you've shaken hands and introduced yourself, is offer him your business card and try and flog him anything. No one goes to these places to be sold to.
Yeah.
Ask him for his business card first. Find out about him.
Yeah.
And then offer him yours.
Yeah.
This is about seeing how you can help somebody else first. Because sure enough, if you help them, they're going to want to help you.
That's what it's about. Some great advice there. My second question was going to be some tips, but Martin's just jumped in there. So we're up to about 20 viewers, guys. We've got about 5 minutes. 5 more minutes we're going to go on for. So if you've got any questions for Martin or myself, just tweet them in, message them in. So just a quick one on the, well, just a question for me actually, just the differences between the Japanese and how they network and here in the UK under the same format.
They are magnificent. They are absolutely magnificent. They've got twice the population we've got over here, half the population of the States. We were brand new over there 10 years ago, and it's been the fastest growing country for about 3 or 4 years running in that 10 years. They network like it's going out of fashion. And the passing of the business card is like it's like a tea ceremony. It's a whole ceremony. And if you dare to take their card with one hand and stick it straight in your pocket, you could wind up with their thumb inserted in your eye socket. It's a whole business. They spend a lot of time building relationships. They are really, really excellent networkers, considering they had no experience of the type of networking that we own the franchise for. We own it for the country. They could teach us a thing or two. They are very excellent. Over here, we're a little bit, and I know this because I'm British, we can be a little bit stiff upper-lipped. We're a little bit reserved about our networking. Well, forget about that, boys and girls. Get out there and make friends. If you go on your networking, if you go to networking events, business networking events, always bear in mind, it should not be considered to be a social thing. It's a business thing. But business is no joke, but it should be fun.
Yeah.
So make it fun. Build relationships with these people. Have social events with them, but the regular business networking meeting should be considered to be business and not social. You will earn money. You can't fail to earn money if you work the system.
Yeah. Yeah, guys. Any last bit of networking questions? Get them in before we finish. Any questions coming in? Any viewers? Okay. Well, I think we are going to pick the best question. Do you want a recap of the questions, or
I'd like Richard's first question, please, if you can.
Richard's first question was: lots of banks offer
that was his second question.
Sorry.
We need your assistant.
Yeah, sorry. Right, Richard J. On your validation point, read the will. Why don't they add page numbers, i.e., page 1 of 2?
Yeah, really simple question, but important, because if there were no page numbers, that will be useless. Richard, you've got it, boy. Well done.
Richard J. the book.
Not this one.
Not this one. Or that one, will be coming to you. We'll get your address, message us your address, and Martin will...
I'll get it posted over to you, Richard.
Okay,
Well done.
he's not going to come round, but he'll post it to
Do you want a cup of tea?
Well, that's if he does the will. So, guys, thanks for joining us. Remember, I am on Fusion Consult, www.fusionconsult.co.uk. Have a look at our website. Any tax queries, anything, just message me, get in touch. If you like the video, private message me on Facebook. Martin, thank you very much for coming in and sharing your wisdom with everyone. Martin's on Guardian Inheritance. That's www.guardianinheritance.com. As he said, if you call the office, make an appointment, they come to your house. The wills are fixed fees, so it's a tremendous service. I can vouch for it myself, and we'll be coming back to you next week. So have a great evening. Thanks for joining us. Bye bye.
Bye bye.